case briefs, and so much more. LSData's got what you're looking for.
A severe conviction for marijuana possession in the 1980s came back into focus as the Virginia Supreme Court scrutinized the details of the trial. The hang-up? Hearsay evidence, the infamous legal concept wherein statements made outside of court can't be used as evidence if utilities to prove a point. In the spring of 1980, Richard Alan Eckhart found himself in legal hot water. Accused of possession with an intent to distribute marijuana, a fateful search of a local residence proved to be Eckhart's downfall. Here, law enforcement found an array of drugs and drug paraphernalia. Yet the 9 occupants, Eckhart included, initially shirked all ownership. The plot thickened when one occupant, Mrs. Tucker, later stepped forward to claim ownership. Despite the gradual revelations, Eckhart maintained his innocence, and investigators found no drugs on his person. This puzzling constellation of facts led to an intriguing courtroom conundrum. Eckhart's legal defense cried foul at the admission of Mrs. Tucker's testimonial, a classic case of contested hearsay. The defense vociferously argued that the court should only consider the fact that Tucker made her statement, rather than its truth or falsehood. However, the court had a different perspective on the issue. The Supreme Court ultimately dismissed Eckhart's appeal, upholding the original conviction. It ruled that the trial court was within its rights to admit Tucker's statement. Any perceived errors in allowing her testimony were considered negligible, and it did nothing to sway the court's decision. Eckhart's 10-year sentence, with 4 years suspended, stood firm, so it seems that even the murkiest points of law can't save you if the court thinks you're guilty.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.